Hello everyone, kumusta po kayo? Sana po ay nasa mabuti kayong kalagayan. Safe po ba bilhin ang lupa kung rights lang ang pinanghahawakan ng nagbebenta nito? Ang ibig ko pong sabihin ay hindi po titulado yung lupa, ngunit ang hawak lamang ng seller ay deed of assignment of rights o transfer of rights o anumang dokumento na di umano'y nagpapatunay na siya ay may rights dun sa lupa. It could also be a deed of extrajudicial settlement na in-execute ng mga heirs over a piece of land, ngunit hindi ito titulado. Ano po ba yung ibig sabihin ng rights sa bentahan ng rights o sa transfer of rights o deed of assignment of rights? Necessarily, of course, ito po yung mga rights na may kinalaman sa lupa. And it could be any of the rights of an owner in what is known to be a bundle of rights. Sa bundle of rights po kasi, the owner has the right to possess, to use, to the fruits, to consume, or to transform or abuse, to dispose, or to recover the property that he or she owns. But there are instances na hindi lang po yung owner ang may right dun sa property. It could be other people may also have rights over that property. Halimbawa, sa easement o servitude, for example, easement of right of way, kung ikaw ang may-ari ng lupa na walang madadaanan, papasok o palabas ng iyong property, maaari kang mag-demand ng right of way doon sa servient estate. So, it is a right of one person over the property of another. Another example ay yung real estate mortgage. Sa real estate mortgage po kasi may karapatan po yung lender o yung mortgagee sa lupa in case of default sa pagbayad ng utang. Maaari po kasi itong ma-foreclose and the property can be sold at a public auction and the proceeds can be applied to satisfy the unpaid debt. In other words, may right po yung lender over the property ng borrower na naka-mortgage. Sa use of frac po naman, yung use of fructuary ay may karapatang gamitin yung property although hindi naman siya ang nagmamayari ng property. At doon po sa lease ng real property, may karapatan po ang nangungupahan doon sa possession, use at enjoyment ng property. In other words, may right yung lessee doon sa property ng lessor. Ilan lang po ito sa mga examples ng real rights over a real property. But I would like to zero in po doon sa real property rights na involved sa pagbenta ng lupa na walang titulo. And let us find out kung safe ba ito bilhin. Bakit nga ba rights lang ang ibinibenta? Well, basically, it is because wala pang grant from the government o confirmation ng title in the form of a certificate of title which is the absolute proof of ownership. Isa sa pinaka-common example po natin dito ay yung lupa na nasa posesyon na ng seller at ng kanyang predecessors in interest for a number of years or decades or since time immemorial. Yung predecessor in interest po ay kung kanino po nanggaling yung property bago po ito napasa kanya. In other words, yung previous owners. Maaari pong ang predecessors in interest ay mismong mga magulang niya na yumaon na dahil minana niya lang ito sa kanila who might have also acquired the property through hereditary succession. O di kaya nabili niya ito from the person who has been in the possession of the property for a long time. In this case, ang basehan po ng right niya ay ang batas mismo which I will be discussing with you briefly. Again, dahil wala pang grant mula sa gobyerno o confirmation ng title mula sa korte, ang usual na dokumento na ginagamit sa pagbenta ng property ay yung deed of assignment of rights o transfer of rights. Actually, it is just a matter of nomenclature. What matters the most is yung laman ng dokumento kung ano ba yung ibinenta. Sa ilalim po ng Republic Act 11573, kung siya po ay isang natural-born Filipino citizen na hindi nagmamay-ari ng mahigit sa 12 hectares of land at siya ay nag-occupy at nag-cultivate either personally or through a predecessor in interest ng alienable and disposable na agricultural land for at least 20 years prior to the filing of the application for agricultural free patent at nagbabayad siya ng real property tax para dito, entitled po siya na maisyuhan ng agricultural free patent for up to 12 hectares na siya namang maging basihan sa pag-issue ng titulo. So when we talk of a transfer of rights, ito po yung rights na tinutukoy natin. As the buyer o transferee, you can exercise only the rights na meron yung seller o transferor. Ang binibili niyo po dito ay yung right to the continued possession at use ng property at ang right to apply for patent o confirmation ng title. Understandably, mas mura po pag rights lang ang binili ninyo dahil maliban po sa napaka-risky po nito, gagastos pa rin po kayo sa pagpapatitulo nito. Similarly, sa ilalim naman po ng Republic Act 10023, kung ang seller o transferor naman po ay isang Filipino citizen at siya ay actual occupant na isang residential land, meaning nakatira siya dun either personally or through his or her predecessor in interest, continuously under a bona fide claim of ownership for 10 years, maaari siyang mag-apply for residential free patent provided na yung lupang ina-applyan niya ay hindi na kailangan for public service and or public use. This is another example ng rights na binibili through the transfer of rights or deed of assignment of rights. Again, what you are actually buying here is, among other things, yung right to the continued possession and use ng property at ang right na mag-apply for patent. But then, gaya ng nasabi ko, may kaakibat po itong risks at costs. So, how do you protect yourself sa ganitong transaction? First, make sure na alienable and disposable land po yung bibilhin ninyo. Naipaliwanag ko na po ito in the previous video. Please watch it later. Hindi po lahat ng lupa ay maaaring angkinin at mapatituluhan. Tanging mga public agricultural lands lang po ang classified as alienable and disposable lands of the public domain. And these are further classified into agricultural, residential, commercial, at industrial lands. Ang mga forest o timberlands, mineral lands, at national parks po ay hindi po classified as alienable and disposable. Maaari po kayong kumuha ng certification mula sa Community Environment and Natural Resources Office ng DENR kung alienable and disposable ba yung lupa. Second, kung gusto nyo po talagang bilhin yung property, tingnan nyo po kung makukumply nyo po yung requirements na nakasaad sa batas for you to be qualified to apply for patent. Dahil kung hindi po kayo qualified o hindi ma-meet yung requirements, mananatiling untitled yung property. I-review nyo po yung mga requirements o qualifications na sinabi ko kanina for agricultural free patent or for judicial confirmation of title at residential free patent. Third, dahil wala po itong titulo, mas prone po ito sa double sale. Kaya kailangan nyo pong i-check kung may pending application na po ito for patent o for titling doon sa sentro ng DENR at sa Register of Deeds. Baka kasi naibenta na rin po ito sa iba at na-i-apply na rin po ito for patent and for titling. Fourth, kung ang ipresenta ng seller sa inyo ay kopya lang ng transfer of rights o deed of assignment of rights mula sa previous owner o di kaya deed of extrajudicial settlement of estate dahil minana lang ito sa mga magulang na yumaon na at walang tax declaration at tax receipts na nagpapatunay na nababayaran yung real property tax, may problema po dito. Kailangan niyo po itong i-check sa local assessor's office dahil dapat po kayong magtaka kung bakit hindi ito nahagip ng tax mapping ng local government unit. O baka naman may tax declaration ito ngunit nasa pangalan ng ibang tao na siyang nagbabayad ng real property tax. Kung talagang wala pa itong tax declaration, pwede pa naman pa itong ma-declare for taxation purposes. Take note po na kailangan niyo po ng ebidensya to prove your claim pag nag-apply po kayo ng patent or judicial confirmation ng title at napakalaki po ng maitulong ng tax declaration at ng tax receipts. As I have mentioned in the previous video, kapag may actual occupation o possession, maaaring maging basis ng claim of ownership ang tax declaration at tax receipts. As a matter of fact, isa po ito sa mga requirements sa pag-apply for agricultural free patent. And fifth and equally important, alamin niyo po kung may actual possession o occupation ba yung seller dun sa lupang ibinibenta niya. That means kailangan niyo pong mag-ocular inspection. Anong right ba ang ibebenta o ita-transfer ng seller sa inyo kung hindi naman pala siya ang may possession ng property? Well, it is really up to you. Timbangin niyo po kung ano yung mga advantages at disadvantages sa pagbili ng lupa kung rights lang ang pinanghahawakan ng seller. Ang masasabi ko lang po ay pag-isipan niyo po ito ng mabuti. Baka mas mura nga ito, ngunit baka mas lalaki yung gastos ninyo pag nagka-problema. One example of transfer o assignment of rights na sa tingin ko po ay relatively safer is the one which involves a house and lot o condominium unit na binili mula sa developer on installment basis. Dahil as long as legitimate yung developer, it is safe to assume na titled yung property. Sa ilalim po kasi ng Republic Act 6552 o Masada Law, kung hindi na po kayang magbayad ng installment buyer o ayaw niya nang ituloy yung transaction, maaari niya pong i-assign o i-transfer yung property sa iba. But still, kailangan niyo pa rin pong mag-exercise ng due diligence. One final note po, yung mga lupa o house and lot na ini-award ng National Housing Authority o NHA under the Socialized Housing Program ng government ay hindi po maaaring ibenta kahit na transfer of rights lang o deed of assignment of rights lang except to other qualified beneficiaries as determined by the NHA. As an exception, maaari po ito matransfer sa heirs through hereditary succession. I hope may natutunan po kayo sa video na ito. Please don't forget to subscribe to this channel, hit that notification bell, like, and share. Always remember, ignorance of the law excuses no one from compliance therewith. I will see you in my next video. Ingat po kayo.